Welcome to the real world of architecture, everyone. I'm absolutely thrilled to be your mentor for today's explainer. In the studio, you've spent countless hours mastering the art of design, drafting beautiful blueprints, and really pushing the boundaries of spatial theory. But today, we're bridging the gap between theoretical design and professional practice. Because out in the real world, rendering a beautiful building is only half the job. The other half is protecting yourself while you actually build it. So, I want to start by throwing a rather jarring question your way. What is the biggest threat to your architecture career? Well, you might be thinking it's a lack of clients, or maybe an economic downturn, or perhaps failing to master the latest design software. But the reality? One of the absolute fastest ways to tear down your career is through legal liabilities. Learning to avoid tearing down your career with legal missteps is honestly just as crucial as learning to build physical structures. If you don't understand the legal framework of this profession, even your absolute best designs can turn into a total liability nightmare. To keep you safe out there, consider this your legal survival itinerary for today's explainer. We're going to cover welcome to the real world, the anatomy of negligence, the standard of practice, liability traps and contracts, and finally, your team, your responsibility. Okay, let's dive into this. Section 1. Welcome to the real world, navigating complex legal environments. The moment you step out of the studio and actually start practicing, you are instantly governed by a massive spectrum of rules. We're talking national statutes, local building codes, administrative rules, and incredibly complex contracts. It's a lot, right? And it's your fundamental duty to practice in compliance with all of it. Generally speaking, the legal issues you'll face fall into two broad buckets. First, we have party disputes. These are your classic conflicts: project delays, a failure in the constructed work, or controversies over your fees. Second, we have administrative proceedings. These deal with the red tape, your professional licensing, dealing with code officials, or seeking variances. Now, what's really fascinating here is that the outcome of those messy party disputes almost always rests heavily on whether you met the legal obligations dictated by the administrative rules. They are deeply, deeply interconnected. Which brings us to Section 2, the anatomy of negligence, breaking down the boogeyman. When a formal dispute pops up, lawyers look for a legal theory to pin on you. And the biggest, most feared claim against architects is, without a doubt, negligence. So let's pull the mask off this boogeyman and break down exactly how a client builds this type of case against you in court. For a client to successfully sue you for negligence, the law requires them to prove 4 distinct components. Step 1 is duty. They have to prove you had a legal obligation to do something. Step 2 is breach. You failed to perform that specific duty. Step 3 is cause. Your breach was the direct, proximate cause of their harm. And step 4 is damage. Actual harm or financial loss resulted from it. Here's the absolutely crucial takeaway. A plaintiff must prove every single one of these sequential steps to win. If they can't prove that your breach actually caused the damage, well, their entire claim falls apart. All right. Section 3. The standard of practice. Your shield in the industry. Now that I've thoroughly terrified you with the anatomy of a lawsuit, let's shift gears and look at your primary defense. This is how we define exactly what that duty component actually entails in the real world. Listen to this definition carefully, maybe even mentally highlight it. The standard of practice is defined as what a reasonably prudent architect would do in the same general locale, in the same time frame, given the same or similar facts and circumstances. You have to memorize this. Because a layperson, judge, or a random jury simply does not have the technical knowledge to unilaterally determine if you messed up, courts absolutely require expert witness testimony to evaluate your work against this exact standard. They literally have to bring in other architects to testify about what a reasonably prudent architect would have done. This builds a massive protective barrier for you. Just consider the contrast for a second. Perfection is an unrealistic client expectation, but reasonably prudent is what the law actually requires. I want to reassure you right now, the law does not require perfection. Architecture is an integration of art and building science. There's always more than one way to design a project. If a third-party reviewer finds a few minor glitches or inconsistencies on your drawings, it does not automatically mean you failed to meet the standard of practice. The law recognizes that successful practice is based on reasoned judgment, not absolute flawlessness. Moving on to Section 4. Liability traps and contracts, accidental promises and uninsurable risks. Here is where eager young professionals often get themselves into really deep trouble. Even though the law only requires reasonable and prudent behavior, you can accidentally expand or raise that standard of practice by the promises you make, especially in your contracts. And this brilliantly illustrates the ultimate trap. I guarantee this basement will never leak. Please, never say this, never write this. By promising a specific project result, or by taking on a contractor's means and methods, you are voluntarily raising the standard of care way above what the law actually requires. You're making yourself responsible for more than the professional standard dictates, which severely increases your liability exposure. The best way to avoid these traps? A rock-solid written contract. It's like a building's foundation. Whether you use a standard industry form or draft a custom agreement, there are 3 terms that are absolutely essential: project scope, project timeframe, and project fees. You must clearly define what you're doing and, honestly, just as importantly, what you are excluding. Missing basic scope definitions or timeframes often leads directly to breach of contract claims, simply because the owner assumed you were going to do something that you never, ever intended to do. Conversely, you've got to watch out for dangerous clauses that owners might try to slip into the paperwork. Be incredibly wary if an owner's contract asks you to adhere to best practices or highest prevailing standards. Why? Because this elevates your standard of practice, creates massive subjectivity, and worse, it might actually be completely uninsurable under your typical professional errors and omissions policy. No way do you want that. Also, pay close attention to broad indemnification provisions. Many owners try to force you to reimburse them for any and all damages, and if the language is too broad, your insurance just won't cover it, leaving your personal or firm's assets totally exposed. To help you visualize these financial risks, let's quickly break down the 2 main damage types. Direct damages are the immediate costs to remedy your negligence. Think along the lines of replacing a set of stairs you designed to the wrong building code. But consequential damages? Those are the indirect financial hits, like the lost revenue from the delayed opening of the facility because they had to rebuild those stairs. Consequential damages can be astronomically high. This is exactly why having a mutual waiver of consequential damages clause in your contract is an absolute necessity to protect your firm from ruinous claims. Furthermore, as you all know, construction is a highly dynamic process. Things change daily. Because of this, you must always document changes in scope, time, and fee with written change orders. Do not rely on a quick handshake on the job site. If a dispute arises later on, a court is going to look for written documentation to determine what the true updated agreement was between you and the owner. Section 5. Your team, your responsibility. Navigating vicarious liability. For our final lesson today, we need to talk about agency relationships. Because as an architect, you rarely work entirely alone. But you need to understand how you can be held legally responsible for the actions of others on your team. Consider how you handle independent consultants, like your mechanical or structural engineers. If you, the architect, hire those independent consultants directly, courts often find that you were contracted to provide the entire scope of design services. That means you hold the primary liability if the consultant messes up. Sure, you can seek indemnification from them later, but if they go bankrupt, you're left holding the bag. On the flip side, if the owner hired the consultants directly, your legal exposure is much more limited. Unless, of course, you accidentally take on responsibility by signing off on their work for payment. And what about your employees? Generally, your architectural firm is entirely responsible for the acts or omissions of your employees during a project. The courts will absolutely hold you accountable. However, there is a limit. The source material actually points out a rather amusing, albeit crazy, exception. A firm is not responsible if an employee acts completely beyond their required role. For example, if they decide to start selling illegal drugs on the job site, assuming the firm didn't know about it, you probably won't be held liable for their criminal side hustle. Finally, just a quick note to be aware that alternative project structures completely shift these liability balances. In a contractor-led design build, you are suddenly a subcontractor to the builder. This can totally compromise the traditional checks and balances where you normally protect the owner from the contractor's shortcuts. And in a joint venture with another firm, you can actually be held jointly and separately responsible for the negligence of your partner. In these scenarios, carefully allocated contractual agreements are more vital than ever. As your mentor, if I can leave you with one defining summary of everything we've covered in this explainer today, it is this. Successful architecture relies as much on a well-negotiated contract as it does on a well-drawn blueprint. Your creative vision is what brings clients to your door, for sure. But prudent behavior, knowing the standard of practice, and meticulous documentation, those are your absolute best defenses against the harsh realities of the legal system. So as you head out there to design the skylines of tomorrow, I leave you with this one final thought to ponder. Take a hard look at your own practices. Are your contracts built on a solid foundation, or are you accidentally designing your own liability? Take control of your legal agreements today so you can freely design the masterpieces of tomorrow. Thanks so much for joining me on this explainer, and I'll see you in the next one.